Thank you so much for this very kind introduction. And I feel that only in the 24 hours since the long travel, I've aged by at least another 10 years. So I don't know about that. It's a tremendous honor to be here, especially as an alumni of this institution. And I want to thank Yuval Shani and Tamar and Michael for their warm welcome. And for including me in this very important event, one in a series of many others that I've been fortunate enough to participate. My focus today is on an article that was recently published, that I published in the McGill Law Journal, titled, "Is Truth-Telling Online Still Reasonable? A Comparative Approach to Extraterritoriality and Defamation Analysis in the Digital Age." So this is extremely timing. A cross between private law, cyber defamation, and the components of cyber defamation across jurisdictions, but also feeding in, as I will refer to during my brief talk, feeding into the greater topic that goes beyond private law of misinformation and democratic institutions. And what can private law, what can defamation specifically from a comparative perspective teach us about information, misinformation, the use of AI in screening truths and non-truths and liability in the digital age. So that's just a preface to where I'm hoping this will go. Over a decade ago, Justice Blair of one of the Ontario Court of Appeal judge asked, "Is there something about internet defamation that distinguishes it from defamation on another medium?" He talks about it being instantaneous, seamless, interactive, blunt, borderless, far-reaching, anonymous, and the greater risk that the anonymous comments will be believed. Now, these thoughts were expressed in a defamation case, as I say, over a decade ago. But this notion of the greater danger that they will be believed feeds into the larger theme that I think private law has a role in addressing, which is the question of misinformation, democratic institutions, the role of platforms in regulating that, if at all. So beyond these comments that were made so long ago, we look at narrative control, enhanced or augmented decision-making, content filtering, using artificial intelligence significantly compounds this issue, going beyond cyber defamation and begging further reflection. So I'm going to go back and forth, bearing in mind, on the one hand, the contribution of cyber defamation as it exists in the civil law society. I come from Quebec, which is a francophone, continental legal tradition subsumed by an anglophone Canadian tradition. So what can the civilian tradition teach us about cyber defamation in particular that may be useful in the end to addressing broader questions of AI and misinformation? So that way we're situating the discussion into this broader question of AI governance, decision-making, and the contextual paradigm of hybrid or layered human-machine responsibility. Going back to defamation more specifically, the civil law, unlike its common law counterpart, as some of you may already know, seeks to minimize the emphasis on proving truth. So the idea is not, the question is not whether the comments that were made, the impugned comments, were truthful or not, but whether they were reasonable in the context. So a question of someone, for instance, harassing an employee. Does it matter that the employee was actually harassed, or is it unreasonable to publicly allege in the workplace that John is harassing his employees, regardless of whether he's actually doing it? Okay? So that sort of approach lends itself well, I argue, to the digital age because of both constitutional reasons, right? There's not this undue burden of proving truth and placing hardships on the plaintiff, and jurisdictional difficulties, which I'll get to later. In the internet age, obviously something that's spoken in one jurisdiction is heard in many others, and that causes a lot of difficulty. One case, which is an Australian case, let me know if anybody has heard about Duffy versus Google, by a show of hands. Duffy versus Google, an Australian case. Okay, so halfway around the world, Duffy against Google, I only heard of it because the case is a cyber tort case that cites the Supreme Court of Canada, of which we're really proud. But as usual, Quebec gets the short end of the stick. It cites the Supreme Court of Canada without noting that the approach that it's actually citing and adopting is a continental approach. So the reason I like this case is through this contextual approach to defamation, it avoids some of the pitfalls of both jurisdiction and problems of speech that we've seen, for example, the right to be forgotten in the digital age. Long story short, Dr. Duffy, who I believe was a psychologist in Australia, had discovered that excerpts of defamatory material had become immediately visible via Google searches, and Google actually suggested defamatory terms. So if you'd put, and you can imagine this with yourself, you'd put the name Janice Duffy, and Google would suggest, and I'm quoting, psycho-stalker. So imagine each of you putting your own name, and Google, or Bing to be fair, but in this case it was Google, would make these autocomplete suggestions that were defamatory. She complained vociferously, but as you can imagine, got absolutely nowhere with that. So rather than, and this is where I'm talking about jurisdiction, rather than attempt to sue the multiple and geographically diverse sources of the communication, in light of the jurisdictional enforcement process, she proceeded to sue the search engine itself, which she deemed publisher of defamatory material. And this was a very difficult case to make, given the previous case law that you might know is quite uniform in the common law world. The court agreed with Dr. Duffy and opined, quote, that if Google personnel were made aware of the existence of the defamatory website, snippets generated by Google's own program and failed to remove them, their continuing existence was a direct result of human inaction rather than merely the result of machine operation. So first important point, I think here, when we think beyond tort and when we think to augmented decision making, and when we think to, well, the decision was merely made by the machine, here you have this reassertion of human control that is result-based, coming from a torts case, that I think by analogy will eventually prove very useful as we discuss automated, augmented decision making. The court proceeds to what it calls the contextual control case, and this is what derives, citing the Supreme Court of Canada, this is what derives from the civilian approach, where the truth of the matter is not determinate, but rather the context, right? Is it reasonable in context to call someone X, Y? Is it reasonable in context to autocomplete? Completely putting aside the issue of whether she is in fact a psycho-stalker and so on and so forth, that discussion not being necessary. So the approach, which is particularly flexible and malleable in a digital age that is porous, anonymous, may serve, if implemented, by de-emphasizing truth and palliating the difficulties of jurisdiction, may keep at bay the spread of some controversial solutions, such as the right to be forgotten, right? So the right to be forgotten sort of emerged because we don't know what to do with expression online that is defamatory and that we can't control, so solutions have come through different channels of the law, previously unexplored channels of the law, the right to be forgotten itself coming from criminal law. But instead, perhaps, tort, and even in the limited scope of defamation, but my analogy going beyond that, can provide some remedies by shifting away from the necessity to prove truth, therefore doing away with burdens on platforms to investigate whether the speech in question is truthful, right? Because you get into, as you know, moving away from private law, you get into very thorny political issues of, was this political allegation actually true? Was this claim true? And who investigates this claim, and so on and so forth, which becomes a gargantuan task that the law has tremendous difficulty solving, and that the platforms themselves perhaps do not, and understandably do not wish to undertake. So shifting the emphasis, as in civil law defamation, away from truth and towards context may be a mere first step, right? Certainly not a parsimonious solution, but a step in shifting paradigms and reflection that is not only useful, I argue, in private law for defamation, because more and more proving the truth has become onerous, rather than saying contextually this expression was problematic. But also beyond, and perhaps the platform responsibility, where you don't necessarily want to expect intermediary third parties to be the be-all, end-all arbiter of truth, but rather expect them to act reasonably in context. And as simple as that may sound, in the civil law, it comes down to that. Did one act reasonably in context? So, whereas I argue elsewhere, as does, and it's always great when you have a firm argument in your mind and then you watch a YouTube conference presentation from, in this case, the Berkman Center, and you realize that somebody else had actually said this. Professor Urs Gasser has argued we need a global approach to internet speech governance more broadly, which of course is extremely thorny when you think of it as a global approach to internet speech regulation, but private law can play an important role in managing or palliating extraterritoriality in the digital age in the interim, at the very least, right? The civilian vision, which I can go on in detail in the question period if you want, I didn't want to go into the technical details too much, but that emphasizes context over truth and reasonableness over truth, is particularly instructive in our social context. So, summarizing this article freshly published in the McGill Law Journal, which I believe is somewhere on the website, we propose to conceptually reorient cyber defamation analysis towards this civil law approach, whose hallmark of flexibility and adaptability, focusing on context rather than intention and truth, lends itself well to the changes that we are now living. And I think it's instructive, and I say this only in parentheses, that the Civil Code itself was developed and revamped in the context of the Industrial Revolution in cooperation with merchants and so on, and we find ourselves in another Industrial Revolution where having these flexible principles developed in conjunction with, in this case, corporate actors and the like, is a renaissance not dissimilar to the one that we've had in the past, although the previous one took 100 years. Pulling it all together in a review titled The Devil is in the Default, my colleague, who you may have heard of, Ian Kerr, was a true sommité of the law, passed away this year tragically. He had cautioned us that artificial intelligence evolves in ways not previously contemplated, right? That is its hallmark. So that is another reason why moving away from pigeonhole approaches, such as insisting on proving truth as we do in tort law in the common law world, may be one that's antiquated, and the civil law's vision, which is more flexible, can assist with providing defaults, harnessing the ordinary rules of negligence and foregoing defenses, offering subtle constructions meant to withstand time. So we're not looking again at truth and falsity, but at the contextual reasonableness of the speech. It is recommended that defamation law evolve towards a negligence standard, if you will, in common law parlance, an evolution which would require plaintiff to make a showing of contextual unreasonableness of the impugned speech, and that analysis subsumes truthfulness and obviates the need for defenses as courts struggle between protecting reputation, value of expression, freedom of expression, and other constitutional values. So for defamation law, this would signify a shift from a binary understanding of truthful and untruthful speech. And as we're in the private law context, I like to step away and sort of think about the public discussion about elections and what goes online and what doesn't go online, and this binary notion between truthful and untruthful speech, and how helpful is that for platforms versus the opportunity for some form of reform offered by defamation law and civil law, which is more a question of decontextualization of tidbits of information that could lead to harm, contextual analysis of the information in question. So truth is part of reasonableness, but not the be-all and end-all. And in the end, what it does is what Irving Goffman had called impression management. And this, and I think time is running short, so I won't go into this, but it feeds into the German concept of the free unfolding of personality and personality rights, which are also enshrined in the Quebec CCQ. And so that personality right, I argue, is an important impression management tool in the digital age, which, as I say, can be transposed to broader issues of AI and decision making. Okay, last thing, jurisdiction. Now, we can all speak for hours and hours and hours and hours about jurisdiction, so I will leave it to probably 1 minute, 2 minutes, or something of the sort. I just want to begin to end where I began, which is the usefulness of the Google versus Duffy case, despite the jurisdictional morass in which we find ourselves in. So compounding the importance of revisiting defamation online is, as we know, one publication can be read pretty much everywhere. And there's a tremendous risk for the injunction model that some of you may be familiar with, issuing an injunction, contradictory injunctions, injunctions being disregarded. I can go on during the question period. The Canadian Supreme Court got a slap in the face when Google, in a different case, went to the Ninth Circuit and said, you know, this decision of this backward Canadian Supreme Court is violating the First Amendment. And the Ninth Circuit said, yes, First Amendment, please ignore the Canadian Supreme Court. And that was basically it. So it weakens, needless to say, institutions and the rule of law. So sometimes going through a private law channel rather than a right to be forgotten type of channel, defamation channel, in the way that Google versus Duffy did, can, and I'm not saying resolve by any means, but palliate some of the jurisdictional difficulties that are otherwise seen to emerge in cases that are framed in public law terms. So it is one tool in an arsenal of many that can help us deal with the vicissitudes of the digital age. So I end with a quote by Emerson about law in the digital, okay, his quote was not about law in the digital age, but applied to law in the digital age. Don't go where the path may lead, so following the case law as it was, go instead where there is no path and leave a trail. And I hope that the civilian approach to defamation can help forge such a trail. Thank you.
Okay, so this is the one. So how many of you, the Facebook and Instagram user, are familiar with this viral post? You know, warning, from tomorrow, all you have ever posted become public. Or the other one that say that the Facebook has a new algorithm that show you only 26 people in your feed. Are you familiar with that? How many of you comment or share those kind of posts? Nobody, yeah. Yeah, so more aware user know that this is baseless. But there's a lot of newspaper article, and also Facebook has known that this is baseless, those viral posts. But despite all this report, those posts continue to see occasional bump in share and comments. We understand that this is baseless, but this sharing as almost epic element. As Don Quixote, who fought the windmill, taught us, the space between pathos and heroism is very narrow. Through sharing this post, millions of individuals, and it's millions, regain control or feel that they regain control over the data, their expression, their social circles, their life. Big internet platforms like Facebook, Amazon, and Google regulate on a daily basis the behavior of these troubled users and a lot of other users. By using new tool of government, these vendors shape our entire public sphere, transforming economic and technological power into political might. In all those processes which enter deeply into the life of the users do not actively participate. Western modern law knows well, public law knows well, at least in theory, how to deal with the authority of states. But this body of law finds itself helpless facing the emerging political authority of platforms. So in this presentation, I will propose a possible way out of this trap. I would suggest creating legal structure that will allow users to organize in representative organization in order to mitigate the power disparity in platform and to protect and fulfill the user's political rights. Instead of the private and impactless voice that we see here, that users doing when they are sharing those posts, user organization will allow them to express collective voice that will intervene and limit the giant platform political power. So this map describes the most popular social media vendors around the world. Facebook is empire. As we all know, if we draw the same map, considering a search engine, mail services map, video sharing services, Google result will be even wider, not to mention Amazon in her niche. So those empires have the power to regulate directly the end user through their social technological infrastructure. I will discuss now those empire internal government structure and the way to approach it. So when we think about norms in platform, we usually consider things like policy, like privacy policy, like content moderation policy. But norms on platform are actually made of these three layers that support and supplement each other. The first is the traditional contractual layer, including mainly the platform term of service, content censorship policies, and privacy rules. The second layer is the user interface that includes the design of the internal architecture of platform. These layers offer a set of options and restrictions that the user can only obey. The third layer is that of algorithmic regulation, which includes the core services of the platform, such as search engine, and also the supporting mechanisms, such as automated content moderation system. Although algorithmic systems that offer, for example, video recommendation in YouTube are not considered usually coercive, they have significant regulative power. Together, all these three layers create regulative amalgam that direct and control the user's choices, daily action, and social connection. The norms that this ensemble create enter in a new and invasive ways into the user decision-making process, into their socialization processes, and into their method of understanding the reality. This ensemble has unique internal logic and jurisprudential characteristics. If we will translate the technological feature into the language of legal theory, we will find out some central jurisprudential feature of the law in the platform. For example, what algorithmic regulations that enable personalized recommendation for video in YouTube, for example, actually doing is deconstructing the individuals by treating them as a collection of data points instead of integrated entities, organizing them into groups not of their choosing and assuming that they will behave and choose like the other members of the group. Algorithmic methods also enable real-time and perfect enforcement, which is not only respond to reality, but alter it. For example, banned content does not necessarily end in punishment, but simply remove, rendering it non-existent. What is more, this regulation is based on norms that operate like a black box whose inner working cannot be known to the subject, following an internal logic of correlation rather than causation. And this regulation is based on constant surveillance of the population. So, when we look on this ensemble of regulation, we can approach it from several perspectives. We can ask about privacy, false news, freedom of expression. My study here is about, what I concern here is the fact that private entities have great governmental power, no matter how enlightened their policies are. For this purpose, it is very important to distinguish between different impact on political freedom that will help us later to shape the current legal response. So the first issue is the arbitrary tyrannical rule. Under the platform authority, the norms are set only by the corporations. This is a classic political problem of domination, the accumulation of arbitrary authority unchecked by the ordinary mechanism of political accountability. A second concern is the violation of the user's political rights. Creating and enforcing a set of law without granting the subject of the law the possibility to participate in the design of the norms violate, first and foremost, the right to autonomy, the right to dignity. In addition, it violates several specific political rights, including the right to self-determination, the right of equality before the law, the right and the opportunity to take part in a conduct of public affair, and so on. A further and different concern is that the major online platforms function today as the architects of the digital public spaces. They control how we talk to each other and how we know and discover facts about the world. They formalize the public sphere rules and manage them from above without the active involvement of the users. And beyond the intrinsic values of political freedom, of political participation and democracy, political participation also has instrumental value. Democracy contributes to the accuracy of the rule and their suitability to the audience. Political participation is also important for educational reasons. The online platform create universes in which individuals are encouraged to enjoy the membership in the community without participating in shaping the community rules. In this way, the user getting used to live in a very particular form of decision-making, in which an inaccessible force dictates right and duty from above without their involvement. Okay, so what can we do about those concerns? So first, indirect regulation could surely mitigate the problem. Antitrust regulation, better data protection, different liability regime for online expression, all of them could and should mitigate the problem. However, even after we will take those important and not easy and maybe not feasible step, the problem of online political authority, I argue, will remain. Why? Because even if we will have like 4 Facebook and 5 Googles with great privacy policies, there are some unique features of the algorithmic regulation that transform the relationship between users and the platform into authoritative relationship. The ability to control the routes user will follow, with which friend they will keep in touch, what information they will receive, what content they will watch, which road they will travel, give platform the ability to regulate the life of individuals, and more than that, the entire populations. The way modern law deal with authoritarian rule is public law. And so there is some attempt today to apply public law norms to private entities. But I argue that it can lead us to this dead end. The concerns lie in the fact that while these entities actually perform public functions, imposing public law obligation on them can not only limit their power, but also give their profit-driven and undemocratic rule legal and political legitimacy. For what is the true meaning of the human rights obligation that apply only to state? The obligation to protect and fulfill rights. Those obligations give the state the discretion to define the local interpretation of rights, the local boundaries of right. These obligations are actually the mandate that give the authority to the state power. Do we want to give the same kind of authority and mandate to corporations? I think no. Does it mean that we should continue to let them rule and shape our public sphere in undemocratic ways? The answer is again no. So what can we do? So as we just saw, abandoning completely the distinction between the private and the public raises significant theoretical difficulties. But, and this is my main point for today, holding to the distinction does not require us to give up the demand for political participation and democracy in platforms. Think about labor law. Labor relations constitute another case in which private entities have political powers to create and enforce norms inside the workplace, thereby reducing the individual's, the worker, political freedom. For the regulation of this relationship, labor law used two kinds of tools. On the one hand, protective law that limits the employer's discretion and protect workers' rights. And on the other hand, the legal system provides legal structure for the existence of labor organizations, which give voice to workers through collective power. I suggest adopting a similar model in regard to online platform political authority. But relying on this parallel case in which the law provides mechanism for democracy-like collective action in the private sphere, this approach would enable us to avoid the need to classify the political power of platform between the private and the public. In doing so, I do not mean to suggest that users are the platform employees. There is a wide discussion about it, I don't enter into. But that there is unique kind of relationship between platform and user that require development of infrastructure for user organization. Imagine that a platform were obliged to present its user with a page in which every user were invited or obliged to select their representative or organizations. The organization will be local organizations with different ideological agenda, promoting different positions relating to online censoring, privacy, intellectual property, freedom of expression, behavioral targeting, and so on. Imagine further that the corporation running such mass platform, not all platform, only mass platform, were required to integrate those organizations in their decision-making processes, either through membership in the board of directors, through alternative, well-defined procedure of informing and consulting with the organization, and even granting them some type of veto right, for example, before election in a country. Okay, so creating such an institutional setup involves legislation that will require the platform to provide tools for the user to organize, along with legislation that will impact the corporate governance of platform and give the user organizations voice in the decision-making processes. In order that such a approach will succeed and will be effective, we need at least two conditions. The first condition is user representation. In recent years, following public criticism, the superpower platform have felt the need to establish new supervisory institutions. For example, you can see here, Google appointed an ethical board, which you can see here, but it abolished it after 1 week. However, in the same way, Facebook has announced a future establishment of an external oversee body that will operate as an appeal court. Despite the importance of these steps, this body do not represent the users themselves, but are expert committees that the corporation appoint. Therefore, the users themselves do not take part in this body, and this body cannot mitigate the violation of the user's political rights and the centralized design of the public sphere, and this body cannot embody the instrumental benefit that comes with democracy. My proposed user organization would rely, therefore, on user representative. This representative would be chosen by the user and would owe them loyalty, while also owing secrecy duties to the companies. The companies, in turn, would be obliged to involve the user organization in their decision-making. In this way, the user would be exercising their political rights, and the significant norms in terms of human rights and the design of the public space would not be imperative imposed from above, but rather a product of public negotiation. The other condition is a collective voice. Given the highly complex nature of contemporary technology and the huge power asymmetries between the users and the platform, it is very difficult in practice for individuals to identify harm and to act for the remedy. Users do not have time, knowledge, or incentive to stand alone against the platform. Therefore, a user organization mechanism must allow collective action and institutionalized, and it should be institutionalized in the corporate governance structure of the company. Without this mechanism, any attempt to encourage user participation will remain isolated and ineffective. For example, Facebook has stated over the years that it is interested in democratic participation of the users. Something like in 2012, they offer the user the opportunity to choose their private, to vote for the privacy policy of the company. The participation of user was really weak. 2 years ago, the company 2 years ago, it suggests future policy where each user would set the content policy for herself from press structure option. Yeah, I'm finishing. Here also, each user is isolated, living in its own policy filter bubble. Political participation is reduced here from collective and communal project into personal one. Here, each user has separate relationship with the corporation. So those ideas cannot address the problem of the absolute rule of the platform, the lack of collective design of the public arena, and the violation of the instrumental value of democracy. In order for these difficulties to be addressed, it's necessary to create mechanisms for collective action and not just individual action. So to conclude, I want to know that this kind of intervention is not completely at odds even with the American legal tradition. Look here what this smart Supreme Court Judge Brandis, of course, said. Only through participation by the many in the responsibility and determination of businesses can Americans secure the moral and the intellectual development which is essential for them, to the maintenance of liberty. Thank you.
Thank you very much, Yuval. Thank you very much, Karen and Tomer, for the great presentations. And I'm going to speak today about the enhanced self-regulation via regulatory intermediation, and I'm going to look at Facebook as my case study and as what basically try to explain the publicness dilemma in Facebook. And you might ask, what is the publicness dilemma? So I will visualize it like this. If you ever think of privatization as the retreat of the state and the rise of private regulation and private law, the publicness puzzle actually asks the other question, which is what makes organization adhere to public values and outcomes. And my argument today is going to be that rule makers and rule takers can rely on regulatory intermediaries as a policy instrument to create regimes of enhanced self-regulation. I might have used a lot of terms, so let me structure my presentation for today, and I will answer those issues today. So the first thing will be media self-regulation. Then I'm going to talk about, mention the richness of content regulation by social media. I'm going to give a theoretical framework, present my research questions and methodology, and of course answer the questions I raised. So bear with me, and I hope you will be interested in what I'm researching here. So what I found interesting with platforms is the idea that it challenges our conceptions of self-regulation. So if we used to regulate publishers, now we are regulating platforms. And platforms are more challenging because they are actually have to balance between much more cases and markets. So if the publisher used to balance between the readers and the advertisers, today the platforms, in a very Jean Tirolian way, actually have to balance between different markets that they have to serve. And that is challenging because the policy instrument that they are using have changed considerably between that change, between those two old and new regulation methods, and for me, I'm trying to understand what has happened in that change and how exactly a regime of self-regulation has evolved. And why it's so interesting? Because I've listed some of maybe even all of the content regulation that platforms are doing. So you might identify several of the issues here, like hate speech, sexual content, graphic content, self-harm, privacy, if you ever think about the right to be forgotten as a way of regulating content, copyrighted content as well. And so we understand that there is a richness of content regulation by platform, and the platform have to, in some way, regulate that complexity. So what are my questions? I'm going to ask three questions. How did the transnational self-regulatory regime surrounding Facebook content regulatory intermediaries has evolved over time? What are the differences between the two regimes that I identify at Facebook? And then how did Facebook actually balance between private and public and private interests between the two regimes, and how they have changed? What are my methods? I'm using policy tracing of Facebook as a case study. I rely a lot on document analysis, elite interviews, which I, of course, promise them confidentiality. I participate in Facebook policy workshop on content moderation, and I rely on secondary sources. And the analytical framework I'm using for my third question is the one offered by Michael Latzer from Switzerland, that he has a mechanism how to compare self-regulatory mechanisms. So what is the theoretical framework? I'm looking at self-regulation, and we have different mechanisms that are proposed by the theory how to basically balance between private and public interests in self-regulation. So some of those mechanisms offer to delegate responsibility by subcontracting some of the responsibility. Co-regulatory mechanism, for instance, offers to share responsibility between the rule makers and the regulated entities. And for example, a meta-regulation mechanism will allow the companies to do self-regulation, but require the regulators to do some form of monitoring over them. Some of the literature have used that, the media and self and co-regulation literature have used that institutional mechanism and theory to explain how self-regulation has worked in media. But interestingly, some of the literature also in both communication, law, and economics have also tried to do that, but less so with self and co-regulation theory. So I'm going to use regulation intermediaries as a theory. And why is it they are so interesting? First of all, regulatory intermediary brings a very important concept to the regime. It allows us to understand that they have different capacities that they bring in that sometimes rule makers and rule takers might lack. I list some of them here. But also they sometimes are being delegated with functions that both the rule makers and rule takers might not be able to do. This is one thing they bring us. But the other thing that the regulatory intermediation theory brings us is an analytical framework. It enables us to understand regulatory regime better than what usually was able before that, when we thought only on rule makers and rule takers. Now we have a third actor that we can conceptualize a regulatory regime with. And in my paper, which of course you have, but I'm writing on now in my draft, is I basically look at how Facebook developed its self-regulatory regime. And I track it from 2004 when it was created. A very interesting point at that time was 2006, when Facebook decided to open itself to everyone. That has made a very important shift in Facebook, because suddenly they didn't have anymore only collegial networks, but also they were allowed themselves to bring in more users, which of course enriched the types of complaints they got from users, which required them in 2009 to develop the first self-regulatory mechanism, which meant institutionalizing policy mechanisms in order to be able to accept and handle the complexity of complaints they received. That worked until 2012, because in 2012, Facebook changed its policies again and started to expand its regime. It decided to join in international mechanisms and work with other actors and start publicizing its rigorous regime for content moderation, which it didn't do until that point. Also interesting, in 2012, it joined the Global Network Initiative, which was the first time it actually officially joined an international body, which is run by civil organization, which required them to audit every 2 years their policies versus international treaties. And now they will be relevant to private corporation. Other actors involved in that project was also Microsoft, Google, as well. And what I found interesting that in 2016 they have again changed their policy mechanism into what I defined as enhanced self-regulation. And why I find that interesting, because all the theory that I presented previously on self-regulation cannot explain this change. And so we needed a new mechanism to explain what it means to be enhanced self-regulation. So just to present what I found when I looked at the first question of how Facebook developed its regime, is I found actually 5 types of regulatory intermediaries that Facebook rely on. We all can figure out the first group, which are the Facebook users. So users are both the rule takers of Facebook regime, but they also benefit from it. But also Facebook rely and delegate some decision making to users. So one example Tomer gave us, for example, is the voting capabilities that happen twice. But in most cases, Facebook will tell users that using privacy mechanisms, they can control the content they use. Facebook will also rely on consultants to inform them and to raise fire alarms about their policies and how they influence that. But that is true for all time. What we discovered in 2012 when they started expanding is the first-party enforcement and implementation. And those are the content reviewer boards, the content reviewers, the engineers that work for Facebook algorithm and develop algorithms for better content implementation, and a group of actors that are also supposed to develop the policy. And this is, according to Facebook, now goes around 30,000 people that are doing it within Facebook. Some of them are contractors, and we're going to address them even further later. What I found interesting in 2016 are the last 2 groups. The first one is a third-party implementation, and think of the Facebook fact checkers, for example, as an example of that. Why are they interesting? Because they bring norms from outside of Facebook into Facebook, but also what is very interesting with fact checkers, and not true so much for third-party auditors, is that they have high discretion and can also directly implement. So if a fact checker decides something that is false, Facebook will not disagree with that decision, and his decision will be implemented directly within the infrastructure of Facebook without interference. Third-party auditors, on the other hand, are, first of all, come from the fact that Facebook joined the Global Network Initiative. So every 2 years it has to be assessed. But also Facebook will call them every time they need, every time they have a problem on a global scale that raises a lot of fire alarms from politics. For example, after Myanmar, where Facebook was accused of helping the military against the minority, the Islamic minority there. So Facebook said we are going to go and do an audit for compliance on content regulation in order to be able to better understand. But again, Facebook bring in external third parties with external norms in order to implement their policies. So what are those interesting? What is interesting and the differences between the thin self-regulation and the enhanced self-regulation is the fact that, first of all, we know that Facebook relies on first-party intermediaries, but under the old regime, they haven't visualized it. They didn't give them much publicity. Under the new regime, those 30,000 are very well addressed by Facebook. They visualize them. They explain what they are doing. They will create videos and show how they make their decisions. They will let them speak. Of course, not in Congress. Those will still be the managers, but when Facebook tries to address how it addresses the issues, Facebook will do that through them. But also we find the third-party regulatory intermediaries. There are some consultants, auditors, fact-checkers. The regulatory, the content review board is also part of that mechanism. But interesting about them, they have a broad and comprehensive discretion, and Facebook chooses them based on professional accountability. So either they have an academic excellence, or they are certified by a third party, meaning Facebook doesn't choose them. It relies on someone else to delegate them with discretion. That means that Facebook will never choose the fact checkers. It will go to Pointer, ask them who is being certified, and then go back and implement, and then decide who can fact checks for Facebook. Why is it interesting? And this mechanism is probably recognized to some people here that I worked with in the IDI project. I try to visualize what it means. So in Facebook whole regime, we had a very strong case of, if you go to your right, of this is the side that go into private interest. So Facebook doesn't use certification, rely a bit on regulatory intermediation, but doesn't mention them at all. It's very central about itself. It regulates itself, it doesn't influence the entire industry. So we are mostly in that side, on the interest side, and the private interest side. What's interesting about the new regime is this. Facebook has moved from that side over this side of the mechanism of the regime. It relies more on public mechanisms. For example, it will hire certified intermediaries. They will use more private enforcement, which it didn't. But also the policymakers will also, in one point, usually around 2016, will join the debate. So if we look at the American DAO currently here, they threat in intervention. So they call Zuckerberg to the Congress in order to tell them, you should self-regulate, or we will regulate you. The Europeans, on the other hand, are much over at the public side. They actually develop participation and accountability mechanisms as part of code of conduct that they adopted. And also they attempt to regulate the entire industry, unlike Facebook, which of course just regulates itself. So now that we understand the dynamics, so the interesting thing to better understand, and I'm going to use Lutzer and other scholars that try to address how to compare those two regimes, the old thin regime and the new extended regime, is first of all to ask whether or not they have common interest in the market. So it's between companies, consumers, and the community. Interestingly, under the old regime, Facebook worked by itself. It will hear public interest actors. It will act benevolently by empowering users, but it won't work with other market leaders, even though those mechanisms exist, such as the Global Network Initiative. Under the new regime, Facebook becomes more transparent. It updates its content policies. It relies on third parties, which it didn't do before, but it also starts working with other actors and establish industry-level cooperation mechanisms and push forward two code of conducts. In the European area, one is with the European Union, and the other one is with Germany, and which it didn't do prior to that. The other thing that Facebook does is develop its institutional and organizational factors. So we look at what Facebook is actually doing internally, and to understand that dynamic between private and public interest. So under the old regime, Facebook set general principles, but she has a problem because it's still implemented differently between different actors. This is why they have to develop the old regime. Under the new regime, on the other hand, two things happens. First, it set principles, but also defines objectives. And again, there is a debate here between the policymakers, the public policymakers, and Facebook. The public policymakers say Facebook needs to have time frames. They have to take down content within an hour, within 24 hours. Facebook says something else. Facebook is saying, well, I can develop this concept called prevalence, which means how many users will see the content before I take it down. And in some cases, it actually happens around the 99%. Facebook can actually identify the content before anyone will see it. In other cases, it's around the 90%. But Facebook says this is the objectives that I want to work with. Of course, no one, maybe only Google and Twitter can handle this kind of mechanism, but policymakers usually prefer a time frame which everyone can use and implement. Facebook also invests in enforcement team. First of all, in numbers, they triple the numbers of content reviewers and people that work on it, and start developing support systems. Facebook will also bring diversity into that mechanism, create hierarchy and oversight for the team. Thirdly, Facebook will we also can look at the review and participation. So under the old regime, it only occurred very limitedly by raising fire alarms. Under the new regime, Facebook created this concept of a mini legislative session, which means that every other week, Facebook will meet an entire team of around 80 to 100 people, employees, located around the world, and they will decide how to develop the policy. The content policy team will offer policy alternative and will give alternatives and see what will be the result of that policy. The stakeholders engagement here will bring external input on those policies, and the engineers and content reviewers will go and look at those alternatives and offer their recommendation and ask for clarifications. Once the policy was approved, the stakeholders engagement team will go outside and try to explain that policy to other actors. But also a very interesting point is that Facebook will attempt to have the policy implemented up to 4 months. And in those 4 months, every 2 weeks, of course, as I mentioned, they will meet up and make the policy better and improve it. Lastly, Facebook, we also look at transparency, and to transparency, I'm also looking at verification. When you think verification, think of that small blue sign that says that someone is actually speaking. So under the old regime, Facebook have an idea of formalization of transparency and limited community standards, very short community standards, only speaks in very broad terms, and they do verification only of users and apps. Under the new regime, Facebook does that on a broader scale. They attempt to develop a new standard for the industry. They empower users, but they also create transparency and verification of ads, the ads archive, and transparency via regulatory intermediation. Again, they go to third party. This time they go to Yale Law School and ask the Yale Law School to approve that their transparency policy is correct. Which again, but they choose Yale, of course, because of their professional and excellence in academia, but not just because of the fact they actually choose them for other reasons. So what are my conclusions based on what I've found? So there are some strengths in enhanced self-regulation versus some weaknesses. And again, sorry for too many words, but I will go through them, and that will be my last point. So the strengths of that enhanced self-regulation is that it helps us highlight changes and compare the publicness of self-regulatory regime. As I explained earlier, what Facebook is doing cannot be explained by previous theories of self-regulation, and enhanced self-regulation helps us do that. It's especially true where cases where there are no changes in public hard or soft rules. And if you all can think about the different laws that were lastly legislated on to address Facebook, there are very few of them around the world, and if they were occurring, you will notice they happened usually after 2016, which I explained is an enhanced self-regulation mechanism. And it helps us go beyond classical rulemaking and rule-taker dichotomies. So we can now separate between platforms as rule makers, and the function it actually delegates to other actors, which I explained there are 5 groups of them. But there are some weaknesses in enhanced self-regulation. We have to address them. There are concerns about their public mandate, legitimacy, and accountability. One thing we notice now in Congress is that Facebook attempts to replace the lack of democratic and legal accountability with professional accountability. So by presenting the fact-checkers, they say we have professional accountability, but they still have trouble with their legal and democratic accountability. Yeah, I'm finishing this. This is my last point. they also have limited transparency and the ability to participate. So if we have no data, it's very hard to address those actors. And lastly, they are concerned about regulatory captures, who point the intermediary. So other than Germany, there are no mechanism now to regulate those actors. Germany have passed a law specifically that deals with those actors. But Facebook is still being criticized. And there's the other point of concerns of regulatory capture. Facebook are criticized for relying on intermediaries that have a political agenda, and also from disconnecting itself. So the fact that Facebook relies on third party and say, we are not giving them standards, they're doing what they want, and they are chosen by third parties, Facebook is actually being criticized for that. And that was my last point, and I'm looking forward for your comments. Thank you.
I have a question to Rotem. So first of all, thanks for your talk. I think it's very interesting that you showed us how Facebook started all this self-regulation. But what I'm asking myself is, or do you think that self-regulation will be enough to tackle all the threats we see in social media, or the manipulation? Because you call it enhanced self-regulation, but what I'm asking myself is, don't we need like at least a form of regulated self-regulation where a regulator sets certain standards and the platforms have to comply, or even like hard forms of regulation? Yeah, I'm from Germany, so maybe it's also my European perspective.
Yeah.
But yeah, I would be happy to hear what you think about that.
Well, both in Germany, just to give a context, so in Germany the new law was actually a result of the fact that the code of conduct that Facebook did with the German government failed, and so they passed the new law there as a result of that. And this is one case where you actually see the fact that self-regulation of Facebook have failed, and so policymakers decided to take a step further and created a country-specific law to regulate Facebook. But you also can start noticing cases where the European Union actually passed new laws, one in 2018 and another in 2019. I might confuse the order, but first I think is the hate speech, and the other is the copyright directive, where they challenge that self-regulatory mechanism. So that happening, of course, on one side of the Atlantic, and you see new concept there. So I think the hate speech directive, and I might be mistaken with the copyright, actually says that that government are incentivized to create co-regulatory mechanism. I think it's Article 4A of that directive. So you see cases where the European Union actually tells the government to develop new co-regulatory mechanisms to regulate specifically on hate speech. In the US, it might not be enough, but they might develop another concept. But currently, I think they are not aware of the fact that both sides of the political debate are not aware that they have the same problem, but they are too interested in their own public interest, and they currently just threaten Facebook. So that pushes Facebook into doing actions, and you see that, but I don't think it's still enough, unlike the European Union, with actually a lot of new concepts of self and co-regulatory mechanisms. And I think it probably will originate from there, where you might find these solutions into the problem of balancing private and public interests.
So thank you all. It was very interesting to listen to all of you. My question is for Karen. So I can simply sympathize with the contextual approach that you're proposing, but I'm sure you heard this comment before. We are compromising our respect to the truth of things, like in this age of misinformation, fake news. The message we're sending here is we cannot know what the truth is, but also maybe we don't care if the law adopts this approach. So,
Thank you very much for this important question. And I wish, especially when hearing Tomel's fantastic paper on a topic that I've also written on in the past, I wish that I could have presented a second paper which had to do with public law and democratic legitimacy. And then I remembered that I think I did present that paper a while ago. This is where, and it's not a neat distinction, there is the lessons of private law and defamation, and that can be applied but only partially to the public sphere and democratic legitimacy. So what happens in the tight context of defamation is that the civil law says there are certain things that are simply unreasonable, and we're not going to waste our time, mostly because it places undue burdens on plaintiffs with the truth, but also because saying truthful things in certain contexts does not exempt you from liability. So the most obvious example, they always have, standing up at a party and saying, this person has harassed their employees, or this person has been promiscuous. And the person then asserting a truth defense and saying, well, it's true, they have been engaging in promiscuous behavior, or they have been harassing employees, but in the civil law that may not be exculpatory, because even if it's true that this person has engaged in such odious behavior, one should not reasonably express it in a context that would cause such severe harm. So the idea is not challenging truth per se and saying it doesn't matter, but rather for the limited purposes of defamation and for liability, saying we care about contextual reasonableness and we will not now be the arbiters of what is true or not. And even if it is true, it won't make a difference because it was unreasonable to express these truthful words in this particular context. So that's for the limited purpose of defamation in a traditional private law, and I too have doubts about the distinction between private and public as we near the digital age. Having said that, and because it's my fault because I said these lessons, because I'm now working on decision making in AI, and I've said we may want to use these lessons for broader public considerations. I, like Tomer, I'm very concerned with democratic legitimacy and imposing, I think, these were your words, imposing public law obligations on commercial actors, and how problematic this is. So for that limited purpose, I would say, and without going into my other paper, which is not here, but having a two-tier where you wouldn't ask the platform to determine the truthfulness of a certain expression, because that would be sliding into a very problematic state function, one that challenges democratic legitimacy, as both my colleagues have spoken of, but rather impose on them contextual obligations, as in Google versus Duffy, where you've been warned this is potentially defamatory, or this has been flagged, and then have a second step, sort of like a hybrid AI solution, or a think fast, think slow that's been developed elsewhere that I can share, only partially developed, where an authority with public legitimacy, as you have said, can then come in and deal with the truthfulness, because I certainly am not a proponent of relativizing truth in the public realm.
So do you, may I follow up? So do you envision this as working in one direction only, expanding the platform's liability? Or would the platform be able to say, okay, maybe it's not true, but it's very reasonable in the context to publish this?
Right, so I'm not a huge fan of necessarily expanding platform liability, because I think that may have a chilling impact on speech. Well, we've gone from one extent where I spoke about hate speech, I think in 2007, and there was a complete refusal to suppress anything by being faithful to a strict First Amendment, to another extreme after the GDPR, where it's easier for people to just remove regardless. So I don't know that liability is the correct incentive, right, for narrative and discourse. But what's important, and that's what happened in Google versus Duffy, is that it was unreasonable for the algorithm to make suggestions such as psychic stalker when someone's name comes up. Now, the question of whether the person truly is a psychic stalker or a psycho stalker is one that will maybe dealt with in courts later. But the unreasonableness of it being published requires the platform to give it some attention and perhaps isolate the content or de-index the content when there is contextual unreasonableness, rather than have the platform begin to arbitrate truth in the limited, and this in the limited context of defamation?
Yes,
Well, first of all, thank you very much for eluding me, all three of you. And I also got a little bit more confused after the three speakers. I'm Sarah Schijers from the University of Leiden in the Netherlands. And I would like to ask you a question to bring, it's mostly, I guess, connected with your topic of civil liability, private liability, moving a little bit back from platform liability to the actual perpetrators and to the actual victims of hate speech, for instance. So we're working with very big public norms here, but what are the odds that any one of us that has been a victim to hate speech on a platform is actually able to get damages, to provide causal link, and to prove that a norm has been breached? And we're not, it seems to me that, and also in your answer, it seems that we're pushing it now to the rich, big platforms who are always relying on freedom of speech. I'm not sure exactly if we're able to reach something there. And then my secondary question here is, when we look at transnational law, and I think both of you said that just now, don't we have an issue here that in this room we are all probably citizens of liberal or of democracies? There are so many countries in the world that do not have a democracy. I mean, you cannot even start this. You might even end up in jail if you do.
Yeah.
It's a very high level question, I realize that.
No, absolutely, and assuming, was it directed?
Yeah, all of you, but yeah, to you first.
But so in terms of the broader question, and we've had, and in a different context, we've been involved in a paper on online hate speech and the obligation of states to suppress and the obligation of platforms. So this is very relevant. This talk only spoke in a very limited manner to defamation, private defamation. I think the greater issue of online hate speech ties in most importantly to democratic governance and democratic legitimacy and the platforms taking on the role of states and so on and so forth, which is, I think, extremely important, but at least to my mind, maybe Thomas has more to say beyond the scope of this particular paper. In terms of people's powers versus the platform, the utility of this is because I've seen very personalities who would otherwise be considered prominent, even policymakers, who have seen themselves besmirched on platforms and were without remedy, not because the platforms were in bad faith, but because the standard response is, well, it's the algorithm. We can't stop the algorithm from giving you these type of suggestions and worse, which I don't even want to say here, when this has happened. So sort of this abdication of responsibility by invoking technical incapacities and saying, well, it's just the algorithm. So what a case like Google versus Duffy does, adopting contextual reasonableness drawn from civil liability, and I could provide the paper, I don't think it's on the website for some sort of glitch, is that it says, look, it doesn't matter. You can't say the algorithm made a mistake using the obiter from Crookes versus Newton from the Canadian case. If that's there is responsibility to take measures and remove it because it's not reasonable contextually, and then the details can be litigated subsequently, rather than asking somebody to go pursue the anonymous defamers halfway around the world and get around jurisdictional issues and get around. So it's just a very tiny first step empowering individuals in the face of defamation and in the face of this new system of governance, if you will.
Okay, do you guys want to jump in on any of this?
Just one.
And then we will collect some questions.
Just about the transnational issue. So usually in public debate, when we have also Facebook representative in the discussion, so when I'm sometimes somebody say that he's really concerned about those kind of private company doing this public decision, so they say, okay, because you coming from liberal state, but what do you want the government of Turkey, the government of Myanmar, will do this decision? It's better that we are doing. We are the liberal, blah, blah, blah. So for them, I want to say that in the present time, the government of Turkey and Myanmar, they are doing that kind of decision, and there's like very tight relationship between these companies and all the government that those companies work in. And what I want that the people in Turkey and the people in Myanmar will decide about the terms, and not the government and not these private companies. So I think this is like a third way to think about this issue. And, okay, I want to ask Karen on the page, do it later for lunch.
Okay, so Einat, you wanted to ask, and then I'll take it. Okay. We'll collect now, don't ask.
I have a question for Tomer. I love your idea, of course, of collective action, and I think it's brilliant. But I'm wondering how, like, the details. First of all, of course, such a collective has to be independent in a sense, and not necessarily be on the platform itself, because once it's on the platform, it's suggested there's the ability of Facebook or whatever to control it in some way. And I'm wondering whether they won't have the same ability if it's going to be an independent, platform algorithm in a sense of so much power that that independence of power of users might not necessarily work in this very authoritarian regime that now exists. So I'm wondering how if we can address these things.
Right, okay, so collecting, yeah.
Yes, I would like to know the idea that Facebook is self-regulating is the idea that one business entity is setting its own rules, but it's not just in a positive way. It's always say, I don't want to abide by the rule of law, and I also don't want the judicial review. If you have a problem, I will set the rules for myself, and if you want to file a claim in court, you won't go to court, you will go to the ethical committee. So my question is self-regulation by one business entity of itself is challenging the rule of law and judicial review, which are fundamental rights for hundreds of years. Can this be challenged by one business entity which has been founded and incorporated just 15 years ago? With all my respect, what do you think about it?
Okay, Dana?
I have a provocative question, and we contemplate about it in the clinic also. And it comes to the scope of how much transparency we can demand from those platforms. I mean, why can't we demand them an open code? I mean, if they manipulate all of our, I mean, obviously they wouldn't want to give them code, but maybe all the other details they give us just wouldn't be enough. So I ask it provocatively, I mean, but...
Well, the IP professor was smiling.
No, I like that. No, I know, but because how much information aside from the code is actually relevant for us?
Yes, Nate.
Hi. Thank you for the presentation. That's a question to both of you. So you described all these mechanisms of authority, external authority of various kinds in order to enhance those self-regulatory actions. But I'm asking, and you mentioned the German example, so I'm asking maybe you can elaborate a bit more about using states as mechanism of authority in order to enhance these kinds of internal regulations or impose internal ethics that has been created in those kind of institutions. And I'm aiming not just to Facebook, but for example, the Digital Geneva Accords and other actions done by similar international entities that are looking at the same materials. So not like in the case, the German case, in which it's an action of a failure of internal, but using the state together with the state to impose
Okay.
Thank you all of you. It was super interesting. I have two short questions. The first one is for you, Karen. And I'm wondering, as we move forward to content moderation like AI, how much empowering I think the plaintiffs by using this contextual approach will actually help if you're facing an automated decision-making system. And another short one for you, Tomer, is that how do you see the responsibility of the platform towards the requirement, the demands of the user organizations? I mean, let's say could they have a strike or decide demands sort of specific things that they want? Eventually, it's a private platform, so how do you see its responsibility towards these organizations?
Okay, so Did you want to ask?
Yeah, very
Yes.
small content.
I hope you're writing down because I'm getting out of there.
Okay, I'll make it very short. So, building on what Michal was saying before, just wanted to know what if it's a question to Karen. If the AI system you suggest using to moderate content online within platform would know that a content is for sure false. Imagine, for instance, negationism. Would it be allowed to delete it? And then on for Rod, I'm sorry. So how much evidence do you need to decide whether a content can be legitimately deleted from a platform? And it is true that at the European level there is a lot of regulation of digital platforms. Myself, I was very surprised that my students here didn't know how much regulation there is at the European level over a platform. And however, if you look at its content, there is a lot of regulation, but very little in terms of enforcement. So look at the whole cycle.
Okay, so turning now to the panel, maybe I can just also throw in, I mean, you know that this is, I think, the first election cycle in the United States where these issues are actually part of the debate. And in a way, Section 230, but also an antitrust approach is being put on the table. And what is your view about this very strong push against the very fundamental legal structures that facilitated everything that we are seeing? Is it going to be the end of the internet as we know it, or is it going to bring about a more democratic and more public law friendly structure? Of course, we don't know exactly what's on the table, but we see where the wind is blowing, at least from the Democrats. So maybe you can respond in reverse order. Maybe, Odin, I can ask you to start, and then we'll go on to Tomer and Karen. You don't have to reply to everything, just pick on the most conspicuous points you want to address.
Right, so just to address your last comment, because it just on my mind, you have to remember that it's true it's mostly a democratic issue, but it's also a Republican issue. They mostly care about taking down the content. Well, so in many cases, because they challenge more Facebook policies, more conservative, not talking about extreme voices, but conservative voices were challenged by Facebook policies, and they were taken down. And so if you look at the congressional debate, you see that the Republicans are criticizing Zuckerberg and the Google CEO about that, about taking down conservative speech. I think I'm going to try to connect 3 points together. Whether it's a challenge of the rules of law, I think, at least what you see in Europe, of course in the other countries there are still no clear explanation what is going to happen there, in Israel and the US. But I think when you look at the changes that the European Union is bringing in, there is some form of response by the law. So, and if you look at hate, for example, of the directive for hate speech, and you think of the idea of co-regulation that they offer there, you see that basically the European Union is pushing back on the rule of law and saying to the government, please make sure that your law can respond to those dynamics and find specific solutions. They wouldn't work, I think, on the European level, but at least on the national level, in one form or another. That relates to the using states as state authority, because again, if you look at the directive, the European Union tells those countries to legislate within their national implementation of the directive mechanisms to handle Facebook and the rest of the platforms, usually the big ones, and that in some form push back into the debate the concept of state authority over those mechanisms. Would that work on the higher level like the UN and the treaties and the more supranational level, I doubt that other countries will do the same, but at least on the supranational level of the European Union, you see some response. And just for the point of the European Authority, the European Authority doesn't have the power to regulate state organization because the member states don't want the European Union sometimes to actually get involved within the European Union. It's an internal politics of the European Union, but the European Union might suggest policies, but the member state won't allow them to regulate German or Dutch or organization because they don't want interruption within their rules. So you can see a lot of new policies, but the European Union will always have a limited authority because of the politics of the European Union that wouldn't allow them to actually implement the reform. This is at least how I see that, but we can talk about it during the break. Lastly, transparency versus authority. I think, at least if we think about representation, I think that Tomer might have some ideas on that, at least from what I understand. If you want representation and you want the content review board to work properly, sometimes you have to understand that you have to waive some transparency to get better accountability. So if you want the board or other representation to actually do their work better and be able to work better inside of Facebook, you might want to think maybe transparency might have to take a step back and allow them to go further into the platform and its regulation. So there might be a dynamic that we have to think what we prefer, accountability or transparency. It might not be always the same.
Okay, so continue with those issues. So to Einat, I surely agree that those kind of organizations should be independent organizations. This is the whole idea that it's not won't be part of it, not will be like ethic committee that the corporation appointed, some independent, and it should be organization in the sense that it should be institutionalized inside the corporate governance structure. And by this, I don't mean that it should be part of the company, but rather that they should have some voice that should be like part of the rules that the company operates. And I imagine that like they will be obliged to put once in a while, 4 years, 2 years, this kind of page that you cannot skip, and this page you can like choose your representative in this page, and the representative and the organization will be in the real board, will be organization. And for example, we could like put like in Germany, the worker can sit in the board, so maybe the worker, the user organization will sit in the board, or we find another channel of participation. And this leads to the question of transparency. I think that this kind of organization could be a really good answer to the question of transparency, because you cannot like, we have a problem, or usually the company said that there is a problem that the code will be completely out there because of gaming the system. But if we have organization that always carries obligation to the company and all fiduciary duties to the user, then we have some kind of solution, because those kind of organization will see that the feed algorithm, for example, or the search engine algorithm, or YouTube recommendation system. They would have like, they could enter this black box, but it won't be like totally out there. So I think it's a way. And to the responsibility, what will be the responsibility of this is a private company. So like we see in other like labor organizations. So they are private company, but labor law do some structural arrangement that will enable workers to have their voice inside the structure of this company, although they are private companies, because we understand that workers are a really important part of this whole structure. And the same for the user, for the data provider, for the personal data provider, for the data subject. So same here. And for what is going on, yeah, I think this is very important years for the regulation of the internet, and the question is not whether we will regulate or not, but what kind of regulation, because now Facebook say, oh, regulation is so important, we want regulations. Of the question, what kind? And I think those kind of companies are really afraid from antitrust regulation more than everything, more than Section 203. So,
But I find your example, for example, of watching seeing the algorithm. If something is trade protected, this is going back to your comment, transparency wouldn't work here, but a representative that can actually go and see the algorithm, that is one great example of where you say, I prefer not to have transparency in order for that representative to be
kind of
able.
transparency. Transparency is not one thing. It depends who the audience, which kind of.
Right, but I consider that for external transparency. So
Okay, you can
people-
continue this.
So I'll go from the specific questions. I think the two questions here that I'll classify just for expediency is specific to the more general question. So because this event was titled Private Law and focusing on what defamation can bring to your question, the idea was that the contextual reasonableness or putting truth aside or minimizing the importance of truth will remove some of the obstacles that would otherwise be faced in an already very onerous climate for claims in the digital age. So that was a very narrow solution to a very narrow problem that feeds into a broader issue that you have asked about, which is judicial review. And that narrow solution, I think, also helps, and that's what the Australian case showed, with jurisdiction. Right? Because jurisdiction has been something that has emasculated courts, and I gave the Canadian example where even a Supreme Court of can I go as far as saying a respected liberal democracy can simply be shut down, right? An injunction can be shut down because it doesn't accord with the public law principles of another country. And so it paralyzes the entire system that we've known in the past. So this very limited sort of remedy for that purpose. And I should say the imbalance of power, there's a Supreme Court case of Canada, if anyone is interested, that goes beyond the defamation context, where the Supreme Court of Canada said all of Facebook's terms and conditions cannot be applied against this person because of the imbalance of power. So there's sort of a revisiting of the concepts that we've seen in the past. Why? Because courts are looking to protect their jurisdiction and the rule of law in light of the encroachment of these private values and private actors that I think Tomer was alluding to. Very quickly, the general question that was asked up front about artificial intelligence. So I can present at least two papers on this very, very important question, but I won't, so don't worry. So I'm not advocating that the AI be used to make these decisions. I'm saying AI is and will increasingly be used to make this decision. What can the law do about it to encadrer, to frame? Thank you, to frame these issues. If you've seen lately the scandal with, and this is tangential, but I think people should be aware of the Barclays card that gave higher credit to men and not women. And how did we know this? Only because a couple made a joint request, because otherwise we would not know, right? And the couple, this married couple, each knew the financial information of the other and were astounded to see that this algorithm, which was neutral and didn't use gender, by proxy ended up systematically giving women less. Why is this relevant to us? Because AI has no flags. You've asked, when do we know when to remove hate? Beyond the issue of determining what is hate, normally if a person goes to an interview and they feel they've been the victim of racism, there's a flag. You feel that there's something wrong, what my regretted colleague would call the ick feeling. AI, you don't necessarily have a flag to tell you that something is wrong so that you can then avail yourself to your question, so that you can avail yourself to the legal remedies. So how will you, putting everything else aside, how will you even avail yourself to the legal remedies, assuming they're still in place, if you don't know that there's something wrong? So there are so many steps that we have to pass to get to that, and a very limited thought, if people are interested, is the piece that I've worked on, which is applying Kahneman's, the economist's paradigm, think fast, think slow. The machine will think fast, but then the human oversight will think slow for the necessary discretion and democratic legitimacy.
Thank you very much. So please join me in thanking this very good panel.